court is back in session in the special review docket, which is scheduled at 9 a.m. on this day's date of February 24, 2022. Next two cases are styled the state of Texas versus Cody O'Neill Gregory. First case is cause number 329794. Second case is cause number 331518. Mr. Gregory, is your full name Cody O'Neill Gregory?
Yes, sir, it is, Your Honor.
Mr. Gregory, would you please raise your right hand? Mr. Gregory, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir, Your Honor, I do.
Mr. Gregory, you may put your hand down.
Yes, sir.
How are you doing, Mr. Gregory?
I'm doing okay, sir. How you doing, Your Honor?
I'm doing fine, and thanks for asking. Mr. Gregory, I have before me a motion to revoke your probation. This motion alleges that on June 17 of 2021, that you were found guilty and assessed, you was found guilty for the offense of terroristic threat, family violence, and you was assessed punishment at a term of 180 days confinement in the Jefferson County Jail and a fine of $500. And in accordance with the provisions of Article 42.12 of the Code of Criminal Procedure of the state of Texas, your confinement was probated for a period of 2 years. On February 3rd of 2022, Jefferson County District Attorney's Office filed this motion to revoke your probation. In this motion, there are 3 allegations. Oops. And state, are you abandoning allegations? Let's see, what happened? Thing disappeared on me. Okay, state, are you abandoning allegations 1 and 2?
Yes, Your Honor.
Mr. O'Neill.
Yes, sir.
Cody O'Neill Gregory. The state is abandoning allegations 1 and 2, and that just simply means that the state will not be going forward on allegations 1 and 2. However, the state will be going forward on allegation number 3. Now, allegation number 3 states that you, Cody O'Neill Gregory, failed to perform community service hours required as ordered by the court in violation of condition 14 of your probation order. Is that true or not true?
True, sir.
Now, Mr. Gregory, are you pleading true to allegation 3 freely and voluntarily?
Yes, sir, I am, Your Honor.
And are you pleading true to allegation 3 because it is true?
Yes, sir.
Mr. Gregory.
Yes, sir.
I have before me a document that is titled Misdemeanor Plea Admonishment. On page 2 of this document, there are a set of initials, CG, on a line next to a box that is checked MTRP, which means motion to revoke probation, true to allegation number 3. Mr. Gregory, did you place your initials on this document?
Yes, sir, I did, Your Honor.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Did you also sign this document?
Yes, sir, I did, Your Honor.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, Mr. Gregory, there's a signature that is above the line that is titled Defendant on this document. Did you also sign this document?
Yes, sir, I did, Your Honor.
At the top of this same document, there are 2 boxes that's checked. the first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir, Your
The
Honor. I
second
do.
box says check, states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir, Your Honor, I do.
Now, Mr. Gregory, prior to signing and initialing these documents, did your attorney, Mr. Vasquez, go over these documents with you?
Yes, sir, he did, Your Honor.
And did you read and understand everything that he went over?
Yes, sir, I did, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, they are, Your Honor.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's 1?
Yes, Your Honor.
Any objections, Mr. Vasquez?
No objection, Your Honor.
Say no objection. State's Exhibit number 1 will be admitted. Mr. Gregory, are you a U.S. citizen?
Yes, sir, I am, Your Honor.
Okay. Mr. Vasquez, you advised and counseled Mr. Gregory. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Gregory, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, totally I am, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Gregory, I will accept your plea of true to allegation number 3. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find to revoke your probation, and your probation is hereby revoked. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, the agreement is for 120 days in jail, with the sentence in this case to run concurrently with the sentence in case number 331518.
Oh, let me see, may I see her affidavit of indigence? Okay, Mr. Gregory,
Yes, sir.
the state is offering that you serve 120 days in the Jefferson County Jail. You will be given credit for any time that you are entitled to get by law. The court cost in this case is $57. Mr. Gregory, will you be able to pay the $57?
No, sir.
Okay, now, Mr. Gregory, I have before me a document that is titled Affidavit of Indigence. And this document, Mr. Gregory, was signed on February 15th of 2022, which was 9 days ago. And it was signed by Judge Sheffield and granting you an appointment for a court-appointed attorney. The court found that you met the eligibility requirements. That simply meant that the court found that you was indigent. This court is also going to make the same finding and now, let me do this here before I do it. Now, Mr. Gregory, is everything in this document still true and correct today?
Yes, sir.
Okay, so Mr. Gregory, I'll make the same finding of indigence, and that just simply means that the court costs in this case will be waived, which means you will not have to pay it pursuant to Article 42.15 of the Texas Code of Criminal Procedure, because the court is finding that you're indigent. Now, Mr. Gregory, do you understand the state's offer and the court's finding?
Yes, sir, I do, sir.
And do you think that is fair and just?
Yes, sir, I do, Your Honor.
And do you accept it?
Yes, sir, I do, Your Honor.
Okay, Mr. Gregory, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Gregory, I have another case here. This case is cause number 331-518. And in this case, I have before me an information that was filed by the district attorney's office. And this information alleges that on or about January 2nd of 2022, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of assault family violence. Mr. Gregory, do you understand what you have been charged with?
Yes, sir, I do, Your Honor.
And to this charge, Mr. Gregory, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor, sir.
Now, Mr. Gregory, are you pleading no contest freely and voluntarily?
Yes, sir, I am, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir, I am, Your Honor.
Okay, now, Mr. Gregory, I have before me a document that is titled Misdemeanor Plea Admonishments. On page 2 of the same document, there are a set of initials, CG, on a line that is titled Nolo Contingere, which means no contest. Mr. Gregory, did you place your initials on this document?
Yes, sir, I did, Your Honor.
And on the third page of the same document, there is a signature above the line that is titled Defendant. Mr. Gregory, did you sign this document?
Yes, sir, I did, Your Honor.
The next document I have is titled Trial Court Certification of Defendant's Right of Appeal. At the bottom of this document, above the line that is titled Defendant, there's a signature. Did you also sign this document?
Yes, sir, I did, Your Honor.
At the top of this document, there are 2 boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir, Your Honor, I do.
Mr. Gregory, did you sign a document out there on paper that is titled Discovery Certification?
Yes, sir, I did, Your Honor.
Now, Mr. Gregory, prior to signing and initialing these documents that I have just mentioned, did your attorney, Mr. Vasquez, go over these documents with you?
Yes, sir, he did, Your Honor.
And did you read and understand everything in these documents?
Yes, sir, Your Honor, I did.
And is everything in these documents true and correct?
Yes, sir, Your Honor, it is.
Okay. Mr. Gregory, are you a U.S. citizen?
Yes, sir, I am, Your Honor.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections, Mr. Vasquez?
No objection, Your Honor.
No objection. State's Exhibits number 1 and 2 are admitted. Mr. Vasquez, you have advised and counseled Mr. Gregory. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Gregory, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, Your Honor, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir, he sure has, sir.
Mr. Gregory, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
The
Hold on.
agreement-
Mr. Kimberly, please put your mic on mute. All right, thank you. Now, State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
The agreement, Your Honor, is for 120 days in jail with the sentence in this case to run concurrently with that in case number 329794.
Okay, Mr. Gregory,
Yes, sir.
the state is offering that you serve 120 days in jail in this case, and you will be given credit for any time that you are entitled to get by law. The court cost in this case is $327, but you will not have to pay the $327 in this case because the court previously found that you to be indigent in the previous case, and so the court will also make the same finding in this case. Now, this case will run concurrent with cause number 329794. Mr. Gregory, do you understand the state's offer?
Yes, sir, I do, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, sir, I do, Your Honor.
And do you accept the state's offer?
Yes, sir, I do, Your Honor.
Okay, Mr. Gregory, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Gregory, because these cases are family violence cases, I must read to you the model written admonishment or the admonition on ineligibility to possess firearm or ammunition. And it reads as follows. In accordance with the Texas Administrative Code, section 176.1, the court hereby admonish you of the following. Number one, you are, by entry of order or judgment, ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code section 46.013, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Order for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective order. Mr. Gregory, you will be given a copy of this ammunition at the jail. This will conclude your cases. Please follow the bailiff, and you have a blessed day.
Yes, sir, thank you.
You're welcome.
Thank you, sir.
Okay, Mr. Vasquez, is that's your last case?
Yes, it is, Your Honor.
Okay, you're free to go, and you have a blessed day.
Thank you. You as well, Your Honor.
Okay, we're gonna get Mr. Lucian Jones next. Lucan Jones.
You want Lucian?
Yeah, Lucan Jones, yeah.
Hey, give me the key to close that box.
I got one right here.
Yeah, we can't see him. I think you must have.
Just turn his camera, Porter.
Okay. The court is in session in cause number 330712. The case is styled the State of Texas versus Lucan Nakoma Jones. We have Mr. Lucan Nakoma Jones, who is appearing via Zoom. We also have appearing in court, Ms. Marva Provo, who is the attorney for Mr. Lucan Jones. And we also have appearing for the State of Texas, Mr. Blake Ham. Mr. Ham, are you ready to proceed?
Yes, Your Honor.
Ms. Provo, are you ready to proceed?
Yes, Your
Honor. This case is set for a incompetency trial pursuant to Article 46B.015 states that if a court finds that a trial to determine whether the defendant is incompetent to stand trial on the request of either party or the motion of the court, and a jury shall make determination. However, under Article 46B.054, it states uncontested incompetency. If the court finds that the evidence exists to support a finding of incompetency to stand trial, and the court and the counsel for each party agree that the defendant is incompetent to stand trial, the court shall proceed in the same manner as if a jury had been impaneled and had found the defendant incompetent to stand trial. So, Ms. Provo, did you get a copy of the psychiatric examination that was performed by Dr. Edward Grapan?
Yes, Your Honor.
Do you object to the findings, conclusions, and recommendations in that examination? Mr. Ham, did you get a copy of the psychiatric examination that was conducted by Dr. Edward Grapan?
Yes, Your Honor.
Do you object to any of the findings, conclusions, and recommendations in that examination?
No, Your Honor.
Okay. Now, Ms. Provo, are you requesting a jury trial or are you waiving a jury trial?
I'm waiving jury trial.
And Mr. Ham?
Same, Your Honor. Waive
Okay.
jury trial.
So the court will take judicial notice of the findings, conclusions, and recommendations in the psychiatric examination that was conducted by Dr. Edward Grapan, and pursuant to Article 46B.054, we will have an uncontested incompetency trial before the court. Now, Ms. Provo, pursuant to Article 1.24 of the Texas Code of Criminal Procedures, it states the proceedings and trials in all courts shall be public. However, pursuant to Liddy versus State, the right to a public trial is not absolute and may be outweighed by other competing rights and interests, such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receives a fair trial. Ms. Provo, are you requesting that this hearing be closed to prevent the disclosure of non-public information?
Yes, Your Honor.
Okay, that the court will find that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced to the defendant, in that it will disclose non-public information. The closure is no broader than necessary to protect that interest. The trial court have considered reasonable alternatives to closing the proceeding, and the court makes the finding that is adequate to support the closure. So at this time, this hearing will be closed to the public.